Welcome to this webinar. To those watching live, apologies for the technical delay that has hampered us this morning. This is an event co-produced by Bucks SENDIAS Service and FactBucks. It's delivered by Bucks SENDIAS, which is the impartial, confidential, arm's-length information, advice and support service for children and young people with special educational needs and disabilities, and their parents and carers. It is sponsored by FactBucks, Families Together in Bucks. This is the forum of parents and carers with children and young people with special educational needs or disabilities, working to ensure that the views of the families are instrumental in shaping services. I'm Andrew Howard, I'm the team leader. This is the 9th webinar we have created. We will be delivering more over the next year, aimed at increasing parents and carer knowledge and abilities to engage with the SEND system. This webinar is being recorded. The slides with clickable links to useful websites and the recording will be shared with you in due course. These will also be available on the FactBucks website and the SENDIAS web pages, details of which will appear at the end. You'll notice that you are automatically muted. Only the presenters will speak. Questions are encouraged though. You're able to type in your question at any time and we will try to answer as many as possible at the end of the session. Please keep questions as general as possible. Questions about individual children are best asked privately by the SENDIAS online contact form available on their web pages. Questions will be moderated before they appear, which may take a few minutes. If your question is not answered, please refer to the information on our web pages and if necessary, contact us using the contact form. A tip: if you're having any kind of connection difficulty to join the session or during it, try logging out and starting again. If it does not clear up the problem, you will be able to access the recorded version of the webinar in due course. Today's webinar will be presented by Sarah Tibble and Stephen Pope, SENDIAS advisors. We've also had contributions from the SEND commissioning team, and that you will see that through the presentation. This webinar is for you if your child is not able to attend school or further education provider because of ill health, exclusion or other reasons. It aims to help you to know your rights and what to expect. The slides will take about an hour and then we'll try and have questions after that within the time lot we've got. So I'll now ask Sarah Tibble to start taking us through the webinar.
Thank you, Andrew. When we're thinking about alternative provision and education otherwise than at school, it's because a child or young person would not otherwise receive education. So what are the legal responsibilities around having an education? Firstly, it's your responsibility as a parent to make sure that your children have a suitable full-time education. This duty is from the Education Act 1996, Section 7. Most of us do this by sending our children to school. This duty applies to children who are of compulsory school age. Suitable, full-time education and compulsory school age have meanings in law which it is useful to know. Let's start with compulsory school age. A child is of compulsory school age the first term after their 5th birthday. Children who turn 5 between the 1st of January and 31st of March will be compulsory school age at the beginning of the school term after the 1st of April. Children who turn 5 between the 1st of April and 31st of August will be compulsory school age at the beginning of the school term after the 1st of September. And finally, children who turn 5 between the 1st of September and 31st of December will be compulsory school age at the beginning of the school term after the 1st of January. A child remains of compulsory school age until the last Friday in June in the school year that they turn 16. This is the law, and you can find the law about this in Section 8 of the Education Act 1996. Once a child is on roll at school, they should be given full-time education. There is no exact legal definition of full-time education. When talking about full-time education, the government usually refers to a circular or briefing for schools issued by the then Department for Education and Skills in 1990. This has recommendations for minimum teaching time per week for children at each key stage, as shown on the slide here, which are widely followed. As a guide, full-time education should be in line with the number of hours provided for that child if they were in school. Suitable education is education which is efficient because it achieves what it sets out to do and is relevant for the age of the child, their ability, their aptitudes, so what they're good at, and any special educational needs they may have. For example, an online learning package for a child who needs a high level of support with reading and understanding information would not be suitable. Suitable education is not just academic. It includes opportunities to develop wider skills, such as interaction with peers. It's defined in Section 19 of the Education Act 1996. So, as we mentioned, it's the parent's duty to make sure that their child of compulsory school age receives full-time, suitable education. If the parent does this by applying for their child to be on roll at a school and makes arrangements for the child to get to school, certain duties will then fall on the local authority to step in if, for a range of reasons, the child is unable to attend. These duties include arranging alternative provision. So, what is alternative provision and who is it for? It's education that's arranged outside of school. It can be arranged by the local authority or schools. It's for children who, because of illness, exclusion and other reasons, would not otherwise receive suitable education. The relevant law is in Section 19 of the Education Act. Alternative provision is for any child of compulsory school age. They might usually attend a state school or independent school. They might have an EHC plan, they might not. In all cases, the aim of alternative provision is to help a child or young person to stay engaged with education, ensure continued development of their knowledge and skills whilst they're unable to attend a setting, and support them to return to an appropriate setting in the future. Alternative provision is not the same as education otherwise than at school, often known as EOTAS. We will discuss EOTAS further on in this webinar. There are lots of different types of alternative provision. Some are based at home and some are elsewhere. Here are some examples. Individual tuition, which can be face-to-face or online. Online schools where students attend lessons in a class with a teacher online. Online learning packages where students access learning materials independently at their own pace. Therapeutic packages such as animal care and equine therapy. And small group learning at designated centres such as those operated by Aspire at their pupil referral units and Orchard House. Alternative provision can be set up by public, voluntary and private sectors and includes both registered and unregistered providers as explained on this slide. Government guidance on alternative provision states, alternative provision should be good quality, registered where appropriate. It should be delivered by high quality staff with suitable training, experience and safeguarding checks. It should have clearly defined objectives relating to personal and academic attainment. Where an intervention is part-time or temporary, it should complement and keep up with the pupil's current curriculum, timetable and qualification route. The appropriateness and effectiveness of alternative provision should be reviewed regularly and changed where needed. In Buckinghamshire, one of the main registered providers of alternative provision is Aspire. They provide pupil referral units or PRUs as alternative provision for children who are excluded. They also run the hospital teaching service and home tuition service for children who are too unwell to attend school. Buckinghamshire Council also has contracts with registered providers as well as a range of bespoke unregistered providers. Alternative providers are growing in number. Their quality can vary considerably. It's very important that due diligence checks are done before an alternative provider is asked to work with a child. Buckinghamshire Council have written guidance that schools are expected to follow when considering using a particular alternative provision. These checks make sure that provision is suitable and meets quality assurance requirements, including regarding safeguarding. As a parent, you can suggest an alternative provider. These due diligence checks would have to be done before it would be possible for the provider to be considered for your child. It's important to bear in mind that what might be right for one student will not automatically be right for another. For example, home-based home tuition may work well for many children. However, if the alternative provision is home-based and you do not feel this will be suitable for your child, perhaps because you have toddlers to supervise or you are working, then make this clear to whoever is arranging the alternative provision. Instead, your child could attend a tuition centre or work with a tutor in a community setting, such as a local library. Also, what is right for your child at one time may change later on if your child's needs change. For example, from not being able to leave the house to being able to attend a local provider. The law on alternative provision is set out in Section 19 of the Education Act 1996. There is also government statutory guidance, including alternative provision guidance from 2013. Statutory guidance means it is law-based and must be followed. The duty is on the local authority, but is usually delegated to schools. It applies to children in all types of school. The duty is only relevant for children of compulsory school age. For young people over compulsory school age, the local authority has the power to arrange alternative provision up to the age of 18, but this is not a duty. This means the local authority can choose to arrange alternative provision, but they do not have to. For any child or young person with an EHC plan, whatever their age, the local authority has a duty to make sure the help described in Section F of the plan is provided, whichever school or education provider they attend. We will talk about this more later in the webinar. The law on how much alternative provision must be provided is set out in Section 19 of the Education Act 1996, as in the blue box on this slide. In brief, the alternative provision must be full-time unless the child is not well enough to receive full-time education. We've already discussed the meaning of full-time on slide 5. As we mentioned, full-time is not defined specifically in law. Generally, pupils in alternative provision should receive the same amount of education as they would receive in a maintained school. Full-time can be made up of 2 or more part-time provisions. There are no hard and fast rules about how much alternative provision is given. However, usually it's understood that an hour of one-to-one tuition is the equivalent of several hours of classroom learning, for example. Case law shows that the duty to provide alternative provision is absolute. It must actually be provided. It's not just about trying to provide it. And lack of resources are not a legal reason for not providing it. Your child's right to alternative provision differ depending on the reason for the alternative provision. Let's look first at what point a child must receive alternative provision if they are unwell, including if they have mental health conditions. Recent government guidance arranging education for children who cannot attend due to health needs says, there is no absolute legal deadline by which local authorities must start to arrange education for children with additional health needs. However, as soon as it is clear that a child will be away from school for 15 days or more because of their health needs, the local authority should arrange suitable alternative provision. The 15 days may be consecutive or over the course of a year. When a local authority arranges alternative education, that education should begin as soon as it is possible and at the latest by the 6th day of the child's absence from school. The summary of responsibilities guidance at the foot of this slide is also recent. It makes clear the duties of school staff, governors, parents and the local authority, when a child's social, emotional and mental health needs are affecting attendance. This includes children with emotionally based school non-attendance, often known as EBSNA. Buckinghamshire has expectations on schools for additional support for children with EBSNA, including strategies and advice available to try to nip non-attendance in the bud before it becomes a problem and might require alternative provision. These expectations are outlined in the toolkit included here and discussed further in our webinar available on our web pages, also linked here. For children who cannot attend due to health needs, Buckinghamshire schools are expected to refer to the home tuition and hospital teaching service. This is for children who cannot attend due to mental health needs as well as medical needs. Schools are responsible for identifying children who need a referral and for completing the referral form. The full guidance, including the referral process, can be found via the link at the foot of this slide. So at what point must your child receive alternative provision if they're excluded? For permanent exclusions, alternative provision must begin from the 6th day following the exclusion. However, it can begin sooner. If your child's been suspended for 5 days or more, then alternative provision must begin from the 6th day following the suspension. This is regardless of whether this is because of one decision to suspend the pupil for the full period or multiple decisions to suspend the pupil for several periods in a row. This is set out in statutory guidance, and we've included the link at the foot of this slide. If you remember, we mentioned that Section 19 of the Education Act 1996 says that alternative provision must be made for children who, for reasons of illness, exclusion or otherwise, cannot attend suitable education. We've talked about children who are unwell and those who are excluded. What about otherwise? Sometimes a child is not able to go to school for other reasons. There is no guidance for this, and requests for alternative provision are considered by the local authority on a case-by-case basis. When considering the need for alternative provision, the local authority must assess how reasonable it is to expect a child to attend a particular school. For example, it could be your child with an EHC plan has moved from another local authority. It's too far to travel to attend the school named on their plan, and Buckinghamshire does not have a suitable school place for them yet. Alternative provision should be arranged while they wait for a suitable school place. For the next part of the webinar, I'm going to hand over to my colleague, Steve.
Thank you, Sarah, and good morning to you all. So, as we've discussed, there are several reasons why a child may need alternative provision. This checklist is a quick way to identify if your child is entitled to this. The eligibility for EOTAS is different and is discussed later in the webinar. Ultimately, children have a right to full-time education. The school and the local authority should be working with you to find a solution so your child can return to education. If your child cannot attend in the meantime, as already mentioned, they're entitled to alternative provision. We suggest that, as soon as possible, you speak to the school and ask for a meeting to discuss what other support can be offered. To get ready for your discussion, we suggest you try to have ready the answer to the questions on this slide. So, when your child was last able to attend, the reasons why they are struggling to attend, what has been tried already and the outcome of this, what education they are receiving now, if any, what you feel will help, and what you feel is needed longer term. Be ready to refer to any evidence you have. We will discuss this further on the next slide. If your child's school does not offer any help, contact the Bucks Education Entitlement Team. And if your child has an EHC plan, contact their ECHO as well. The evidence it will be helpful for you to refer to will vary depending on the reason for the alternative provision being asked for. In cases of suspension from school of 6 days or more, a permanent exclusion, your child's school will have sent you a letter or email with details of the exclusion. Usually, the alternative provision will be arranged without you having to ask. If necessary, speak to your child's school and the Buckinghamshire Exclusions and Reintegration Team. If a referral to the Home Tuition and Hospital Teaching Service is appropriate, what evidence might be asked for? Well, the recent statutory guidance called Arranging Education for Children Who Cannot Attend Due to Health Needs says, local authorities working closely with the child's home school, medical practitioners such as a GP or consultant, and the child's family should make every effort to minimise the disruption to a child's education by identifying the most suitable provision. Where specific medical evidence, such as that provided by a medical practitioner, is not readily available, the child's home, school, or the local authority should consider liaising with other medical practitioners and consider other evidence to ensure appropriate provision can be arranged as soon as possible. We would advise sharing any relevant medical evidence you have with the school. However, there are no requirements to provide evidence for a particular practitioner, such as a consultant, and it is important that alternative provision is put in place as soon as possible. If you have spoken to your child's school about their illness and there is a problem having alternative provision arranged, contact the Education Entitlement Team. Lastly, if there are other reasons for requesting alternative provision, the evidence will depend on the circumstances. Professional confirmation that it is not feasible for your child to attend school will be relevant, perhaps in a letter or the minutes from a meeting. Again, if you have contacted the school and there is a problem having alternative provision arranged, contact the Education Entitlement Team. If your child is not able to attend school, they may be entitled to alternative provision. There are 3 other options which may be suggested for your child, which are important for you to know about. Direction off-site to manage behaviour, reduced or part-time timetables, and managed moves. We will deal with each in turn. Firstly, off-site direction. This is when a governing board of a maintained school requires a pupil to attend another education setting in order to improve the child's behaviour. It is a legal power for schools maintained by the local authority. Some academies can direct a child off-site if this option is included in their funding agreement or articles of association. It can be used to avoid suspensions or permanent exclusion. Educating off-site is more likely to be effective if the family is in agreement, but schools can educate off-site without parental permission. It is intended to be used when other options have been tried and have not worked. The statutory guidance called Suspension and Permanent Exclusion from Maintained Schools, Academies and Pupil Referral Units in England states, where interventions or targeted support have not been successful in improving a pupil's behaviour, off-site direction should be used to arrange time-limited placements at an alternative provision or another mainstream school. Off-site direction can be full-time or a combination of part-time support in alternative provision and continued mainstream education, totaling full-time. It depends on individual needs. It should be time-limited, and the reintegration plan should be kept under review by the governing body. Another big step which you may hear about is a part-time or reduced timetable. So, what do you need to consider if someone suggests that your child attends only for part of the school day? A reduced timetable is always short-term, the shortest time possible, usually for 6 weeks at the most, and is intended to lead to a return to full-time education. It should never be used as a form of exclusion or to manage behaviour. The government is clear that schools do not have the right to force parents to agree to a reduced timetable, and that they should be used in very exceptional circumstances as a last resort where it is in the pupil's best interest to meet their individual needs. This is detailed in the Department for Education guidance, working together to improve school attendance. As we have mentioned, all pupils of compulsory school age are entitled to full-time education. This means that even if you agree to a reduced timetable, unless your child is too unwell for full-time education or otherwise can't at that moment access full-time provision, they may be entitled to alternative provision for the time when they are not at school. if that is agreed to be in their best interest. This alternative provision does not have to be at your home unless that is your preference. Parents do not have to agree to a reduced timetable. Buckinghamshire Council expects schools to get your written agreement before setting up a reduced timetable and to let the Council's exclusions and reintegration team know that the timetable is in place. The agreement with you should include what to expect in terms of gradually increasing the timetable, how the arrangement will be reviewed, and a clear end date, by which time your child should be attending school full time. Even with this agreement, schools are responsible for the safeguarding and welfare of pupils off-site during school hours. If you have concerns, for example, that a reduced timetable is going on for too long, or the hours in school are not going up, speak to your school again, and if necessary, contact the exclusions team. If your child has an EHC plan, we suggest you speak to your ECHO if a reduced timetable is suggested by the school, and also consider requesting an early annual review of the EHC plan. You can find out more about how to do this on the link on this slide. In some cases, a managed move might be suggested as an alternative to setting up long-term alternative provision. A managed move is a supported way of introducing a child to a new school for a fresh start. It must have the agreement of the parents and/or carers and the receiving school. If the managed move fails, the child remains on roll at their original school. There is more information about managed moves on the link at the foot of this slide. So, how does alternative provision fit in with SEND support plans? If a child or young person has SEND support, alternative provision should be recorded in the SEND support plan. It should be clear which outcomes the alternative provision is supporting. The impact of the alternative provision should be reviewed as part of the SEND support plan. SEND support plan reviews should take place at least termly, and you can find out more about SEND support in mainstream schools in our link at the foot of this slide. Now, thinking about how alternative provision fits with EHC plans, first let's remind ourselves about the help in an EHC plan. If the help is written into section F of the EHC plan, the local authority must arrange for it to be provided. When this help is provided, the education of the child will be suitable. If the child is receiving more than very short-term alternative provision, this should be discussed at the annual review and written into section F of the EHC plan. For a child with an EHC plan, a common other reason for alternative provision to be arranged is because the help set out in section F of the EHC plan to reach a particular outcome cannot all be provided by one provider, such as the school. For example, animal therapy to support a student's mental health outcome might be provided at an outdoor centre. Sometimes alternative provision may take place in the school setting, e.g. specialist SEND tuition. The expectation is that the required alternative provision is specified in section F, provision of the EHCP. If the school named on the EHCP tells you it can no longer meet your child's needs, or the child is being excluded or otherwise not attending, it will be important to call an annual review. The school can do this, or you can ask for one by contacting your ECHO and the school. At the annual review meeting, decisions can be made about whether alternative provision should be set up. Try to get a clear agreement on who will be funding and who will be arranging this, the local authority or the school. The local authority, in our case, Buckinghamshire Council, is ultimately responsible for making sure that alternative provision is in place when necessary. However, they delegate funds to schools to meet the cost of EHC plans. There's no hard and fast rule about who pays for alternative provision in these cases, which can cause confusion and delay. So, what are some requirements about education for children and young people who are below and above compulsory school age? Well, there's no legal requirement to educate children below compulsory school age. Young people must continue in educational training until at least their 18th birthday, so after compulsory school age. The legal requirement is on the young person to participate, not the parent. Local authorities have broad duties to help and encourage young people to take part in education or training. Any young person aged 16 or 17 is entitled to the offer of a suitable place to continue with their education and training for the following academic year. Local authorities have a power, not a duty, to arrange education provision when not already available for pupils aged 16 to 18. So there is no duty for local authorities to provide alternative provision for children below and above compulsory school age. The exception would be if they have an EHC plan, as discussed on the previous slide, as the help in the plan must be delivered. If the help can't be delivered by the early years setting or further education provider named in section I of the EHC plan, the expectation will be that an annual review is held and arrangements are made for help to be provided through alternative provision. Here we have a few frequently asked questions. So with the first one, my child is managing to attend school a few hours a week. Are they still entitled to alternative provision? In this case, the answer is yes. If your child is only able to attend part-time, they are not receiving full-time suitable education, so they are entitled to alternative provision. The second question, the school have put together a plan to help my child return to school. Is my child still entitled to alternative provision in the meantime? The answer, again, is yes. They're entitled to alternative provision. Regardless of what plans are put in place, your child will not receive suitable full-time education without alternative provision. Alternative provision can be put in place whilst your child transitions back into school. The third question, I have been told my child has been signed off as being too unwell to attend school before they can be referred for alternative provision. Is this the case? No, this is not the case. Some alternative providers have referral criteria. However, if your child is entitled to alternative provision, it is the duty of the local authority to provide this. If your child does not meet the criteria for a particular provider, the local authority should look for a different provider. There is no requirement for a child to be signed off before they can be referred for alternative provision. The fourth question, my child is unable to attend school, but I've been told they are not eligible for home tuition provision. What can I do? Ask the school whether a referral has been made and what the response was. In some cases, you or the school have additional information that may support the referral. If you have already followed this step, ask the school for a referral to a different alternative provider. If your child needs alternative provision, the local authority have a duty to provide it. Question 5. I've been told the school does not have enough funding for alternative provision. What can I do? If a school does not have the resources to provide alternative provision, they can ask for additional funding from the local authority. This is called high needs block funding. The school will evidence how they have already spent the nominal £6,000 allocated to all children for SEN support. However, if a child is entitled to alternative provision, the local authority have a duty to provide it, regardless of funding arrangements with the school. And the last question, 6, I don't think the alternative provision my child has been given is suitable for them. If you don't think the alternative provision is right for your child, contact the provider initially and see what can be done. If this doesn't help, contact your child's school, use their complaints process if necessary. If your child has an EHC plan, contact your ECHO and if necessary, again, make a complaint. There is information about this at the foot of this slide. If a complaint does not resolve your issues, you also have the right to ask for your case to be investigated by the local government and social care ombudsman. So education other than at school is a very specific type of alternative provision for children or young people who have an EHCP and who are not able to attend any type of school. If EOTAS is agreed, the child or young person's education is made up entirely of alternative provision. So providers of the types we have already discussed on slides 8 and 9. This could be delivered by one or more providers. It differs from elective home education, also called homeschooling. This is where parents are responsible for providing and paying for all the help and education a homeschool child needs. When EOTAS is agreed, the local authority is responsible for making sure that the education and help that EHC in the EHCP is provided and paid for. EOTAS is agreed where the local authority are satisfied that there are no suitable schools for the child or young person. Section 61 of the Children and Families Act specifies the circumstances under which EOTAS can be agreed by the local authority. It says that the local authority, and again, in this case, Buckinghamshire Council, has the power to consent to a child or young person with SEND being educated somewhere other than at school or post-16 institution, typically at home, but only where the authority is satisfied that it would be inappropriate for the provision to be made in a school or post-16 institution or at such a place. Where a child or young person can access some of their education at a school or post-16 institution, the local authority are unlikely to agree to EOTAS. Case law dictates that if EOTAS is agreed, the placement in Section I of the EHCP is left blank and the alternative provision is specified in Section F. The effectiveness of the EOTAS package and whether EOTAS is still appropriate will be reviewed at least annually via the annual review process. So, if it appears that education at a school or similar setting is not going to be appropriate for your child or young person, what steps should you follow? As a first step, speak with your ECHO to find out whether EOTAS might be a possibility for your child. The next step would be to discuss EOTAS at an annual review of the EHC plan. Annual reviews should happen at least annually. You can ask for an annual review if necessary. More information about annual reviews can be found on our web pages. In Buckinghamshire, the process is that parents will be asked to complete a personal budget form. The form requires you to give details of suitable alternative provision, approximate costs, and to explain how this provision will meet your child or young person's needs. This request is then considered by a Buckinghamshire Council panel of professionals. They will look at information and look at the information you provide about what you want the money for and how much it will cost. They make their decision in relation to the law around personal budgets and the local personal budget policy. If the request is agreed, parents will be offered a choice of how the personal budget and EOTAS package is administered. So, what is a personal budget? A personal budget sets out the amount of money that is available to spend on support for your child to meet their assessed needs. In Buckinghamshire, personal budgets may be available relating to education, which will require an EHC plan. It could be used for health, social care, transport. The aim is to give you more choice and control. It is not extra money. For children with an EHC plan, the personal budget will be sufficient to meet the outcomes in Section E of the EHC plan. If you choose to manage the budget yourself, you receive money via a direct payment. If you decide to do this, you will have the responsibility for sourcing providers, paying providers directly, and all the obligations which arise from being an employer, for example, around safeguarding, health and safety, and employment. If you choose for the local authority to manage the personal budget, the local authority will take on all of these responsibilities. Sections 9.110 to 9.118 of the SEND Code of Practice tells you more about what can be included in a personal budget, and you can find out more information on our web pages. Now, I'd like to pass you back to Sarah Smith, the manager of SENDIAS, who will describe the role of the SEND NEAT team. NEAT stands for Not in Education, Employment or Training. Alternative provision and EOTAS may be useful options for children and young people who are NEAT. Over to you, Sarah.
Thank you, Andrew. Thank you, Steve. Sorry. So what does the SEND NEAT team do? The SEND NEAT team sits within the integrated SEND service and coordinates the offer to young people who are NEAT, so not in education, employment or training, with an education, health and care plan. And their work includes communication, activities in the community, work in schools and tracking, and we'll talk a little bit more about those. The goal of the NEAT team is to reduce the numbers of young people with EHC plans in Buckinghamshire who are NEAT. The work is broad and covers prevention, so working with schools and alternative provisions, as well as those with individual packages, EOTAS and electively home educated young people to identify, track and support young people who are at risk of being NEET. It involves identification and tracking, working with education, health and care coordinators and with providers, young people and their families to identify the young people who are at risk of being NEET. It also involves direct work with young people, and it involves advice and guidance, so providing specialist advice and guidance for council colleagues and community groups. Another aspect of the NEET team is their work in developing new opportunities for education, employment, training and volunteering. This includes developing a database, which we will cover more on the next slide, and sharing the information from the database widely. The work also includes networking with employers and training providers to encourage them in providing opportunities for NEET and disabled young people. There is a link at the foot of this slide which will take you to some examples of opportunities. As I mentioned, the NEET team has developed a very useful spreadsheet. This is very much a work in progress. It aims to include the full range of provision available as listed with the headings on this slide. It is a live document which SENDIAS and other council teams can use to help you to find out what is available for your young person. The NEET team welcomes referrals and their details are here. The NEET team is organising a post-16 opportunities showcase next week, which may be of interest to you. It is particularly useful if your young person is looking for something different rather than attending college or sixth form.
Thank you, everyone, Sarah and Stephen and Sarah, for just a final few words about SENDIAS. If you require further information to help you, please refer to the SENDIAS web pages, and if necessary, contact the service via their clickable form. If you want a quick response to a general query, you could try out the web chat service and see the link on the web pages. This is available during term time between 1 and 3 on a Monday and 10 and 12 on a Friday. If you aren't able to use the contact form, you could find other ways to contact the service on their web pages. They aim to provide an initial response within 10 days, and that is dominated, I'm afraid, by the number of staff to the number of inquiries ratio. And finally, just a reminder about FactBucks. We are the Parent Carer Forum. We exist to give voice to parents and carers into the SEND system. We have a new website which is live. Please do take a chance to look at that if you have a moment. So now we're going to move on to questions. We're going to continue the webinar for a little longer than published in order that we can do some of those questions because we started later. If you can't stay on, then please you can pick up those questions later when you see the recording. We'll begin with a question from Katie. She'd just like to know who has the responsibility for provision of education, bearing in mind that after compulsory school age, since an educational health and care plan can go up to the age of 25. Sarah, is that one for you?
Yep, that's I'll have a go at that one. Thank you, Andrew and Katie. Yes, thank you, Andrew. Yes, so I'm hoping, I think you asked that question quite early on, Katie. I'm hoping that you've gathered a little bit of an answer from the slides. So slides 22 and 23, when you receive the recorded version and the PDF of this webinar later on, will do cover that to some extent. So basically, there's because the young person has an EHC plan, there's a duty on the local authority to enforce to provide the provision in the EHC plan in section F. So that duty carries on as long as the EHC plan is live for your young person. So whether or not they are over compulsory school age, so over 16. So that's one thing. There are also some duties, as we looked at on slide 23. There's requirements for young people to remain in education until at least their 18th birthday. That sort of duty is actually on the young person themselves. Yeah, local authorities do have a power to arrange education provision where not already available for young people of that age. So that means they don't absolutely have to, but they can, and they might do in certain circumstances. So I hope that answers your question. Did anybody else want to chip in?
I think that's fine. Thank you. We'll go on to the next question. We've had a question about responsibility for managing an EOTAS package, which parents can find very demanding because there are many different providers to deal with. I think the parent, Julie, was assuming that in a school, the SENCO would provide the coordination for the alternative, any EOP that was being offered, since out of school. But in this role, that she had assumed that the ECHO would do it, but that doesn't seem to happen. It is quite demanding when you have more than one child, or even you don't just have one child. Is there a responsibility on the local authority to manage and coordinate that, or does it always fall on the parent?
That's a very good question. So I think this question is more about, because we do, I think there's another question later on around sort of sourcing the help in the first place. I think this is more about, well, you've got a package in place and it's about coordinating that. And I think that we do find that parents do often seem to have to take more of a role in coordinating the support, and you've talked about sharing information. And then I think if you're having difficulties with that, then please do contact SENDIAS and we can try to help you to work through that and see if there's another. It sounds as if, as for many young people, children in this situation, that a key worker might be helpful, that kind of approach. If parents, some parents want to do that and have the time and resources to do so, but many don't. I think it might be one that we could possibly talk through with you and see what could be done differently. The other question later on, I think, was around the expectation of managing the personal budget as a direct payment. So I think that was Alison's query. Andrew, should we move on to that as it's sort of connected? So as we talked about in the slides, the personal budget is it's simply the amount of money. It sets out the amount of money, and then that can be managed in different ways if it's agreed that that you're going to have a personal budget. So it shouldn't automatically have to be you having it as a direct payment and then having to take on all the responsibilities of sourcing and basically employing people to support your child. You could ask Buckinghamshire Council to manage it, or you could ask a third party to manage it, and those options should be made available to you when when all of this is being talked about. Which is when it'll be as part of the annual review process once you've got a plan. Should we have the next question, Andrew?
Yes, so we have two questions that are very similar, one from Katie and one from Abby, where it's about the statement about AP within section F of an education, health and care plan. It seems that there seems to be reluctance on many parts, both in terms of the providers and the council, to specify what that AP provision should be in section F. And then if it is actually specified, how we can get people to stick to making the provision that's noted. So is it required to be in section F in detail, and then what steps can be taken if it's not being provided?
Okay, yes, thank you. Yes, so I would say that you wouldn't necessarily expect the name of the provider to be in section F, but the provision itself, so what it will encompass, should be in section F. As many of you will know, the provision in section F should be specified and quantified, and there's information, a lot of information about that on the IPSI website, so it's worth having a look at that. Yes, I wouldn't necessarily, yes, I wouldn't expect them to be naming providers, because it's more about getting that provision in place, where however it's, whoever is delivering it. Did anybody else have anything else to say about that one?
No, I'd agree. We not normally named, as you say, the providers aren't normally named, but it just needs to be very clear what that provision is and what it's going to achieve.
Thank you. Next
Okay,
one, Andrew.
so
Yeah.
we have a question about the length of time it would take for a personal budget or EOTAS to be for the personal budget or the direct payments to be received after they're agreed. So what is the usual expectation of time delay between an agreement for a personal budget for EOTAS and actually the money being received?
I think that can be very variable. Has anyone got anything else to say about that?
I'm sorry, I don't have any guidance, no.
I think that with a lot of parents experience a delay, and it's due usually to systems within the council, so we can take that one up as fact box. There is a general delay in terms of direct payments, and it happens in social care as well as in education, and it's not acceptable, but it does happen. A question from is alternative provision still possible for a child in year 10? And the answer I can give you is yes, year 10 is within compulsory age, so yes, it's absolutely fine. We had a long question from Inga about personal budgets and elective home education, and whether or not there was an opportunity here for the local authority to think in a creative way and fund in part elective home education, which of course is a right, it's a choice technically under the law. You can educate your child at home. That's quite a detailed question that really we need to refer to the SEND team, and we'll do that one. So we'll take that away, and we will come back to you with an answer to that in due course. What other questions have we had? I think we might have There's a question from Laura saying that we're now being talked about there being a delay in availability of AP, and people are now talking about a waiting list of 4 months or so. Is that the experience of the team, that there is a delay in providing alternative provision and there is some sort of waiting list, a bit like we have for other services?
I think if you're being told that there's a delay and there's a particular provision isn't available, I think it would be talking to school about well, can we try somewhere else then? I don't. It's some sorts of alternative provision are very limited in terms of what's available, and it might be that is the only thing that would suit your child or young person, but there may it's worth looking further afield, yeah, so I don't think I'd sort of accept that at face value. In the meantime, if your child isn't being educated, that's obviously not appropriate. They need to be in full-time suitable education if they are well enough for that.
Yeah, I think we're aware that there are certain providers, that there's very high demand for certain providers. But as we said, there are a lot of alternative providers sort of coming into it all the time. So it's going to be a matter of the local authorities and the schools looking, as Sarah says, sort of actively looking for what else is there out there in the meantime. And we've had sometimes examples of schools saying they're not going to make a referral because there are long delays, which obviously isn't acceptable.
There's a lot. We have a lot of questions arriving at the end, and we're coming towards the end of the time. I did say that we were asked a question specifically whether or not there's a policy for EOTAS for Bucks County Council. And at the moment, as far as I'm aware, there isn't a stated policy, although that is being worked on. We had a specific question. Someone missed the answer to the question about how provision can be enforced if it's not actually being delivered as it's written into a plan or as it's agreed. That seems a good question, Sarah.
Yes. Okay. Yes. So that one basically it would be about contacting your education, health and care coordinator. If you have difficulty contacting your ECHO, then you can try their senior person. If you look on our web pages, so the SENDIAS web pages on the Buckinghamshire Council website, we have a section called working with professionals, and that includes the contact details for that you would need to sort of escalate your concern if you're having difficulty getting that heard. So basically what we'd expect to happen is if the help in your plan isn't being provided, it would be speaking first with the school and giving them an opportunity to talk with you about it and give their point of view, and it may be that something more is happening than you had realized. But yes, if you're still not satisfied, then it would definitely be raising that with your education, health and care coordinator. Again, if you look at the IPSI website, there's a section on enforcing your EAC plan. So have a look at that and see if that helps you. If you still have problems around that, then yes, as I said, please do contact us using our contact form.
We have a question about where do you go to when the school says no to alternative provision?
So yes, so again, I hope that was answered on the slide. So if your child does not have an EAC plan, then you would go to the county attendance team, and there was information about that on the slides. I'm sure one of us will put that on the on these question answers in a minute. And also, if your child does have an EHC plan, I'd also contact your ECHO.
I think that's the time we shall draw this webinar to a close. Thank you for attending. There are a number of questions that have been not been able to answer, and we will be providing some follow-up statements to help those questions. Obviously, please contact the service if you need follow-up. Some of the questions are specifically about the current nature of the service for the provision of AP and EOTAS and understanding amongst parents and parents' concerns about it. This is a growing area of activity in the SEN world, and one that FactBucks is aware of and engaging in conversation with the iSend service. And so a lot of the questions we shall be taking forward in order to get some more substantive answers, and particularly a statement of policy on these things to do with AP and EOTAS. It is an area that it will be under the spotlight come the next Ofsted inspection of local area provision for SEN, which is due sometime probably in 2025. So again, thank you. If you have time to offer us feedback, please do so. There is some feedback in the chat, and we will take that on board. We will be offering another webinar in February on preparing for adulthood, particularly based on independent living, and there will be one specifically after Easter on ADHD. But in the meantime, thank you for attending.